Okay, so let's hope it's gonna work. So basically what I'm doing is to generate presentation for all the topics that we're gonna face during the exam session. Okay, so I'm gonna start from IP, and IP is the biggest actually exam that we have because we have trademarks, patent law, and copyright law. All these three are the basic standard. Then there could be even trade secrets, but that's a smaller part. I think that with patent law and trademarks and copyright, basically you cover most of the question that we might have basically in the final exam. That, as we know, is an open question if I don't mistake. So my idea is to try to make every night a presentation, basically not tomorrow because tomorrow is the last day of the year, but tonight I have time for doing that. And yeah, basically that's what I'm gonna do. I'm gonna give all this presentation to you, hopefully they will be helpful both for you and for me. And maybe, I say maybe, I'm gonna and we are gonna achieve a great result at the exam. So I hope. So let's start. So first thing to ask ourselves is, what is copyright? Okay, so of course copyright is one aspect of IP law, but the first thing to remind is that it does not protect ideas, but instead protect their expression. Their expression. So this one is called the idea expression dichotomy, and it's very interesting actually because it actually is actually talking about what is protected by law is the expression of the idea. So the original expression that could be fixed or not depending on the jurisdiction. We're gonna see this later. And it is a product of authorship. What does it mean as expression? Expression is the way in which the idea is extroverted in the world. Okay, so that's what is protected, the way in which it is extroverted. So it could be on a tangible medium, and in that case is fixed, so there is the fixation requirement, or it doesn't. This depends on the jurisdiction, because common law jurisdiction as UK or US normally has the fixation requirement, while other jurisdiction as the European one doesn't have. Regarding China, for example, we have the fixation requirement too, but they have a peculiar kind of actual copyright system, and we're gonna see that. So from what I say, you could see what are the main characteristics of copyright. Is the originality that surrounds the expression and an authorship, and as fourth requirements, there could be fixation depending on the jurisdiction, being a civil law or a common law country, but better say depending on European civil law based jurisdiction or US based common law jurisdiction. Now, how did the copyright develop? Now, I know this part is maybe the less important of the whole presentation actually, and the less useful, but I'm gonna briefly try to discuss it. So the idea of copyright came from the printing business and from printing monopolies, okay, that normally were given from someone like a king or in the Republic of Venice, for example, by the Republic to someone to printing its own books. So before the printing publishing, maybe there wasn't. This debated probably. From the 1557, the UK didn't have anymore this model, but instead give monopolies over book publication to a guild that was the stationers company. This one is the first time in history in which there are representative of particular market sector, that is the one of the publishers, that is gonna take all the copyrights, so all the monopolies on in terms of copyright, an eternal monopoly. This one is a model that is problematic, of course, on the long run, because as we know, the monopoly of copyright is limited by time in contemporary copyright law, although we are talking about a very broad amount of time, okay? And we know that having a perpetual monopoly is always negative in terms of the market development itself. So already in the 1710th in UK, the Statute of Anne was developed, in which for the first time the whole copyright law was granted on a monopoly in regards to the author. Okay, so the author of the copyrighted work has the right to publish it and a monopoly on its publication. Now this is really important because we're gonna see how the main component of copywriting, basically all the jurisdiction, that is the right of publication, the right of reproduction, the right of distribution, are deeply connected with this idea, the idea of printing, basically, no? So of the book printing business, okay? Because the book printing business is based on publication, distribution, and reproduction, and basically on contain such right in the hands of the copyright holder. Now it is interesting because this same kind of interpretation of the right finds itself in a problematic spot when we talk about contemporary technologies. And probably I'm gonna face that at some point in the presentation. So when we're talking about AI, for example, but especially when we're talking about download, uploads, when we're talking about a first sale doctrine applied to NFTs, for example, in China, there is a big debate on this right now in their academia. So try to think that what I'm saying right here and what I'm going to say in the presentation, the idea I'm going to deliver to you is basically that we have a copyright system that came from ages ago, that has developed inside the idea of a particular sector of the economy and the market, and right now is challenged by the contemporary innovation. So we are talking about centuries of history that right now could face radical changes, if not facing complete annihilation in front of market sectors that literally doesn't need that anymore, or better, that are completely different from what it was intended to. Now, here I stop in 1710, but actually there are three other important treaties. One are the one of the 19th century. Regarding copyright, the important one is the Berne Convention of 1881. And then the second one is the Rome Convention 1961. And the third one is the WIPO Copyright Convention of 1996. So 1996, so we're talking about something fairly recent, not super recent, but fairly recent. Why are they important? Because we are talking here about the origin of copyright and when the copyright came from. But we need to take into consideration even how much the story I'm talking to you right now is the story of the UK, that was the pioneer, we could say, on this. But US has a different approach, a very different approach on copyright than all basically other countries that signed even the Berne Convention. China had a different history in regards of copyright. For example, in China, copyright was already drafted, started and interpreted, some say even from Middle Ages. So we're talking about 14th century, and they have a strong legal culture that came from there and that had been disrupted during time in facing both the colonization from the European from one side, from the other side the globalization, so the global market, and the third side is the innovation that is coming to China. China that one day has to get literally find himself to be one giant market that becomes the center of the world as it is right now. And so in in this consideration, take into consideration that what I described here is the UK perspective, because it was a pioneer in our Western world. But what is important is even to consider the harmonization attempts that worldwide had been established during the 19th century and the 20th century in order to achieve anything, basically, and to have something that was much more equalized in every country. It was achieved in some sense, in some other it wasn't. For example, moral rights. Now let's talk about theory. I'm gonna be super fast on this because, as I know, is the wishy-washy part that is not very interesting maybe, but is important at least for understanding what is behind the thinking of the legislator of various countries. So in the circle you actually see Jeremy Bentham, that was actually a utilitarist philosopher, a very famous one actually, and his corpse right now had been conserved, mummified, and it is in exposition. I don't know even where. I think in US, surely in US, but I remember if it was in Washington, Philadelphia, something like that. Actually there is his corpse, and it's crazy because they try to recreate, for example, his eyes, his bulbs of his eyes, and actually they put him with with an azure eye, like if he had, you know, blue eyes. It's pretty interesting in a way, right? I mean, because any kind of painting we have of him actually has brown eyes, so why? But anyways, why I'm quoting Jeremy Bentham? Because Jeremy Bentham had been a very influential figure in the US jurisprudence, okay? So in the interpretation of law and legal philosophy in US. And thence the utilitaristic approach had entered into the US legal system. And we could actually see that even in the copyright, because the aim of the copyright for the utilitarian argument, the utilitarian perspective, is the idea of an incentive to intellectual production of the country. So you are going to produce more because you know you're going to be protected, right? And hence we could see the utilitarian argument, the utilitarian incentivization argument is basically everywhere. You're going to see in the IP. In the great IP world, right? You see even in the patent world, basically, you know, in which the idea is promoting invention and the inventive steps in the country, and therefore innovations in the country. Here, as it is copyright, is not innovation that is taken into consideration. If you remember, we spoke before, is the expression of a creative idea. So what the incentive we want to achieve is actually to give the possibility of incentivize the intellectual production of intellectual expression and creative idea, but not inventions, nor designs or anything else, or distinctiveness that is much more of trademarks. The second argument instead is the natural rights argument. This one is very interesting. Why? Because this one is totally another word, basically, right? This one came from the German word, okay? And the idea of natural rights came from the German word and the French word, especially the one that came after the revolution. So you see how they are these two arguments are sons and daughters of the Enlightenment, basically. But if beyond the Atlantic, the Enlightenment created the US revolution, the revolution for independence, that hence is a struggle for independence based on neoliberalism and on economic liberalism and utilitaristic principles. In the old world, in Europe, in France, for example, it was based on the idea of achieving equality, equal rights for everybody. There was no independence to achieve because France at that time was actually a great imperial power, so they didn't need to be independent by no one. They were the epicenter of continental Europe. What was interesting for them and what was necessary in 1789 for the French people was actually to reach equality, so to destroy l'ancien régime, the old regime, in order to create a new state, a new vision that is based on equality. Here is where the natural rights argument came from, that hence gives much more, that gives much more sense. Io vado a fare i nani. Va bene, arriva tra poco. Sorry, it was my girlfriend. Anyways, where I was, okay. So what I was saying was natural rights, the epicenter is the human being. So the IP right stems from the human rights of the human being. So there is a human rights to the authorship of what my intellect generates, okay, of the expression of my intellect. So the expression of the intellect is the expression of actually myself, and thence it is an extension of the individuality and the rights of that individuality. This one is the line of thought that generated the moral rights inside, alongside the economic rights of the copyrights. So you see how much history and theory had generated the shape of copyright as it is today, basically, right? Then there is the third argument, that is that such IP rights are stimulating the economic growth of any country. This one is the economic or neoliberal argument. Now we start with the hard stuff, okay? So with the important stuff. What is the subject matter of the copyright? So the subject of the copyright protection are two main features: authorship and human agency that is behind the creative work. As we said before, the epicenter is the human mind that is generating anything, an expression of its ingenuity and originality. It's not the work behind it, but it's the spark of creativity, the direct link between the ideas of the author and uniquely from them to the work of art, okay? Then depending of the jurisdiction, you would have fixation, like in the common law jurisdictions, or the necessity of being transposed, as we said before, on a physical object, on a physical media, and neighboring rights. That means what could be, for example, recordings of the creative work, representation of it, that are copyright rights that stems from the relation with the creative work. This could be my filming of someone else dancing, of someone else playing, okay, or my representation of a Shakespeare drama, of Macbeth, or anything like that. You see what I mean? Then let's go on with the first extra, that is actually how the subject matter is regulated in China, Europe, and US. Okay, so let's see one by one, and we start from the US. So from the US law. So okay, so quoting section 102 subparagraph A and letter A of 17 USC, especially Copyright Act, original works of authorship. The subject matter of copyright is original work of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or a device. So we have two main important elements that are the authorship and the originality, as we said before, but even fixation. So authorship is mentioned here as being formed by a human element, so it comes from human agency, and from the other to be causally connected to the human agent. So authorship is the human agency and the connection between the work generated by it. So there is the work generated by it that needs to be linked to such human agency and the authorship, right? In this way, you create the authorship link. Another requirements that we have seen in section 102 letter A is the fixation. So that copyright exists when the creation is fixed on any type of medium that is tangible. You see here the main problem, that is tangible, okay? Hence that exists, that is physical, right? The consensus of the author in order to have the fixation is necessary. In UK it's not like that. For example, in UK this is different. It's not necessarily the consensus of the author. So I could, for example, go to the house of Mozart, talk with Mozart as Salieri did in that movie that is called now Amadeus, and go there, listen to Mozart talk, and write the opera that is talking to me about how it's gonna work, how it's thinking it's gonna work, and create hence a copy of it that is not authorized by Mozart itself. In that case, for UK law, the fixation principle had been satisfied, even if there hasn't been the consensus. While in US law, this is not fixation. Fixation happens with two requirements: a tangible medium, but especially the consensus from the author. Okay, fixation comes from the Berne Convention of 1886, as we said before, that at Article 2.2 describes that any member states could actually decide to use the fixation principle inside its own legislation. Another important requirement, as we said before, is the originality, okay? A concept that, as I said previously, it doesn't concern with novelty or distinctiveness. Novelty is an appanage, is a requirement that normally is linked to patent law, while distinctiveness to trademark law, and we're gonna talk about them a lot when I'm gonna face that arguments. But instead, the originality have been described better, been collapsed with the origination requirement, because in the Copyright Act, originality is not actually defined in the US. The origination requirements requires that the work must originate within the author. So remember, on the authorship, the casual link that there is between the work and the human agency, but on the other side must embody a spark of creativity. So we have an interesting case from 1991 that is Feist versus Rural Telephone, in which the Supreme Court linked originality to actually the US Constitution, that in Article 1, Section 8, Clause 8, that talks about it in Art 1, Section 8, Clause 8, and defined the idea of a spark of creativity. You see how low the threshold is the USA, because we're not talking about the non-obviousness requirement, the novelty requirement that there is, for example, in patent. We're talking about something pretty low. We're talking just about a spark of creativity. Simply not be a banal intuition, okay, but something that contains a spark of originality that represent the human agency to which the work is linked. So this one is the idea. Let's go to see now European law. Authorship, European law, the European copyright framework that we have, actually is mostly silent on the question of copyright subject matter and authorship itself. But there is extreme attempts to harmonization on a European level. Article 1 of the term directive came pretty close to a definition by referring the copyright subject matter as a literary or artistic work within the meaning of Article 2 of the Berne Convention. Okay? In its own jurisprudence, the Court of Justice of the European Union seeks guidance actually from the Berne Convention and the reference to TRIPS agreements and the WCT in order to satisfy the necessity of having subject matter and authorship. Now let's see an important case from 2009, that is the Infopack case, in which the Court of Justice of the European Union extrapolated a general autonomous concept under European law of the work as the author's own intellectual creation. Here the authorship had been defined as an intellectual creation and had been confirmed in later judgments like Levola Hengelo, Funke Median, Coffee-Mill and Prompton Bicycle. Now, an important question is the question that was seen before in the US, the human agency. Although EU copyright law nowhere states that copyright requires a human creator, has anyway an anthropocentric focus, especially related to human authorship. The clearest evidence is the opinion of the general advocate Trysteniak, that reported that an interpretation of Article 6 from the term directive that is clear that only human creation are protected, even the one in which a technical aid is employed, such as a camera, for example. So the opinion of Advocate General Trysteniak, that then was endorsed by the court, is the fact that there is a human agency in the concept of authorship in European Union. However, such a human agency is not clarified anywhere, and even the idea of, as we say, of authorship is very loosely defined in Article 1 of the Term Directive of 2006, and in Infopack is just mentioned that copyright is the author's own intellectual creation, the work on intellectual creation. So we know broad concepts, but they have not been developed fully yet into the legislation. Originality. So the matter of originality is something very interesting for the reason that is actually actually always from the Infopack we use the same words, the author's own intellectual creation, for knowing that there is is not copied, and it is an intellectual creation, and hence it is the originality. I know it's pretty, I know it's pretty abstract in comparison to the US, okay? But the idea is that, as we say in the InfoPack case in 2009, the Court of Justice say that the work must be an author's own intellectual creation, okay? From here we know that there is an author, hence the authorship requirement, that there is an own, author's own, so that is something that is owned by the author, okay, and thence is related to the author and doesn't have any other disturbance, any other infiltration by any other agent, hence the direct link, okay, and the fact that it needs to be an intellectual creation, okay. This one is what generates for us the originality, the fact that there is no copy, okay, that is just related to the author, and that we have an intellectual creation, so an intellectual creation that is just from the author, and thence the originality. Then we have what was held by the Court of Justice in the case Levola Hengelo and Kofemel, in which it was held that the subject matter must be original in the sense that, as we say, the author's own intellectual creation, as reaffirming the InfoPack interpretation. In Piner and Funky Median, the court then went deeper on this, clarifying that intellectual creation implies originality, so that the intellectual creation is one of the basis of the originality, which in turn implies making personal and positive choices, so making choices by the author itself. These have been confirmed in Brompton Bicycle and in Kofemel. So the idea of originality in the EU is linked to the author's itself capacity of generating intellectual creation, and thence of making personal creative choices related to the work, basically. So is the human agency in that sense. Now we're gonna see Chinese law, okay? So let's go further. Chinese law. Okay, Chinese law is a little bit simpler because we have the authorship right law of 1990 that is actually their copyright standard, that at Article 2 defines the subject matter of the copyright as works of Chinese citizens, legal person or unincorporated organization, whether published or not, that have hence the copyright. And in Article 3, that for the purpose of the RLL of this law, the term works means intellectual achievement in the fields of literature, art, and science, which are original and can be expressed in certain form. Hence, we have a series of requirements in China that are: the first, that the work must deem it a work of authorship, right? So a work by a Chinese citizen, any legal person, or any unincorporated organization, both published and unpublished. It must be original, as we said from Article 3, even if unpublished, and there is the tangible medium of expression, a fixed nature criterion that reports that a work should be fixed in a certain substantive form. On Article 3 is even given the list of the tangible way in which this could be achieved. Returning on originality, as we got in Article 3 of the RL, the originality in China could be further divided into independent creation and creativity. Independent creation means that the work is being conceived independently, while creativity means that the work demonstrates spiritual labor and a mental judgment of the author. You see how much in the US we have much more an independent creation approach, okay? So in the US they're saying to you there is a link between person A and person B, and under section 1 or 2 it must be original in the sense that there is a direct link, a causation link between that author and the outcome of the work, as well as a minimum spark of creativity, as we have seen in Faced case with rural Kerignac. Okay, while in the EU we have seen that there is an accent in the info pack and funk median and so on, that there is a much more interest into what is called the positive role of the author. So the author has the positive role, the positive role of making choices related to that work. It's not just related on the independence of the creation, but even creativity in sense of a judgment by the author in what choices to be made in order to achieve the expression as he would like. This positive endeavors is the one that reflects the authors and then put his mark on it. So you see how China is taking the two approaches and merging them inside his article 3. Now, let's go with the boundaries. An important case is Chao Qingkang versus Chongqing cigarette plant, in which is said that the Chinese copyright law protect works that independently convey views, information, ideas, and feelings, and that few words on title few words isolated on a design or anything could not constitute an independent original work, and hence this one is not eligible for copyright protection. Sorry, I wanted to make you see the graphics. So let's return to the broader discussion we were doing. So we're talking about the subject matter. So what subjects are the matter of the copyright, but which rights are collected inside the broader umbrella of copyright. So as we say, the centrality here comes with the author. Okay, so the will and the agency of the author, and there's a series of the exclusive rights. So you would have economic rights and moral rights depending on the jurisdiction. So what the international treaties see are reproduction right, distribution right, public performance, right of the communication, and rental rights. So we have 5 main economic rights. So the production, distribution, public performance, right of communication, and rental right. Then on the moral side instead you have the right to authorship and the right to object any modification which will be prejudicial to the honor or the reputation of the author. How it is reproduction right treated internationally. In the Berne Convention, in Article 9, is stated how authors of literary and artistic works shall have the exclusive right of authorizing the reproduction of the copyrighted work in any manner or any form. It is matter of the legislation of the countries signing the Berne Convention that there could be special cases. There could be special cases that could be accepted. No, this one is the article that gives the possibility of fair use and accepted or lawfully use of copyrighted material. but it balances it with a test, a proficiency test, we could say, that is from a side that such utilization, such reproduction is not going to conflict with the normal exploitation of the work from a side, and on the second side, it doesn't prejudice the legitimate interest of the author. So then the distribution right is instead foreseen in the WIPO Convention of 1996 on the Article 6. So we have the production right, Article 9 of the Berne Convention, while distribution right is in the WIPO Convention on the Article 6, in which is mentioned how much the authors of literary and artistic works should enjoy the exclusive right of authorizing the making available to the public of the original and copies of the works through sale or other transfer of ownership. Hence, through the rights of distribution, the authors have the possibility of not making available or making available, of accepting or not accepting that the public could access the copies or its original work in any means possible. Of course, there's always the possibility of the party to contract. This is seen in the Article 6 in the Article 6 of the WIPO Convention, but still, this possibility is basically what gives the possibility of the first sale doctrine in the US or the exhaustion doctrine in the EU, in the European Union. What does it mean? That after there has been a sale, after there has been a contractual term in which there has been a transfer of the copyright ownership, the distribution right for the copyright holder, the first copyright holder, the author itself, is gonna end. Why? Because the ownership had passed, and then even the possibility, basically, of distribution, of the right of distribution, is concluded. Then, of course, there are differences, there are similarities, and we're gonna see them immediately when we're going to talk about China, US, and European approach on this. Then let's go with the public performance. The right of public performance instead is Article 9 of the Berne Convention. So for now, in the Berne Convention, we have seen right of reproduction on Article 9 and the right of public performance in Article 11. Okay, while in the WIPO at Article 6, we have seen the right to distribution. So in the Berne Convention is mentioned that authors of dramatico-musical and musical works shall enjoy the exclusive right of authorizing the public performance of the works and any communication of the public of the performance of the work. This is extended by the Berne Convention even to translations, okay, that are made of the copyright work. You see that this one is the first right that we are treating, the first economic right that is linked to a particular type of authors, okay, is connected with a particular type of authors and not to others. As if I am a software developer, I don't have the right of public performance because there won't be a public performance related to my product, okay? Hence, this one is just to see how much even the exclusive rights that are granted by international treaties, for example, now the Berne Convention, have limits. One of them is literally that there are rights that are tailored in the interpretation of who is going to use them. So, of the authors that are going to use them. And we're going to see how much this interpretation had been poured into national legislation, US, EU, and China. We have seen them. So, Article 11, right of public performance for the Berne Convention. Then we go with the right of communication. That is the right to authorize any communication to the public by wire or wireless means, including the making available to the public of works in a way that the member of the public may access the work from a place and at a time that is individually chosen by them. This one was thought actually for televisions, but then it had been poured into hyperlinks treatment, right, of communication in relation to hyperlinks and the internet itself. So you see how much, right? You were thinking to use them to patch the right of communication to TV broadcasting, and this was even done in China, right? In China was done the same, but yet in just the span of 15 years, 20 years, the same rights had to face the fact that it's going to be used in an online perspective. And we're going to see the main problems here. The main problems that this kind of exclusive rights actually face with the new technologies later in the presentation, even a little bit later now. But one thing I could tell you is basically this one had been extended to hyperlinks, okay? And even downloads, for example, or even there was a great talking about the right to exhaustion or first sale doctrine in relation to downloads and so on. And in the EU, the European Union, it was interpreted as the downloads as a communication, as a right to communication. And why? Because it's not actually a sale, okay, transfer of ownership in the European perspective, because I'm gonna take one copy and I'm gonna make a copy for you, right? So you're gonna download it, but the content is still gonna stay in my hands. So it's not actually, even if I'm selling something to you, I'm selling you the possibility of so on, of downloading the content. For example, try to think about a scientific paper. Still, in the European perspective, there has not been a transfer of the matter, actually, of the work itself. The work not been transferred, but has been duplicated. I kept one copy of the work, you kept a second, and you go away and you could sell it and so on. So, in the European perspective, this has been interpreted as a right of communication under Article 8 of the WIPO Convention, and we're going to see even about the Infrastructure Directive, while in the US, the first sale doctrine has been applied, and we're going to see where and so on, especially in relation to e-books, for example, right? And then these are demonstrated that same technology and same instruments could actually be changed, because even the US has a right of performance and right of communication that actually are kind of merged together, but they exist, okay? Same thing as in Europe, and both of them, they have exhaustion and first sale doctrine that are basically the same, just with different names. But yet, the outcomes are actually opposite. In Europe, they will say to you, the download is actually an act of communication, and thence right of communication of the copyright holder applies. In US, they're going to say to you, this one is a clear transfer of ownership, and thence exhaustion and prior sale doctrine applies. Anyways, the right of communication, as we say, is the right to authorize or stop any communication that is done to the public by wire or wireless means and making available of the public of works in a way that the members of the public could access such work from a place and a time that they chosen. Okay, right of communication is super important for us in the 21st century, and it comes from the WIPO Convention of 1996, precisely Article 8. Okay, so for now, try to remember a mental scheme of this. We have 2 rights from WIPO, 2 rights from Berne Convention. From Berne Convention, the most ancient, 1886, we have reproduction right, and we have performance rights. Reproduction rights at Article 9, performance rights at Article 11. Why? WIPO Convention has at Article 6 distribution right, and at Article 8 right of communication. Let's go further. Rental. This one is another important right, the rental right. That is the right to authorize the commercial rental of the original copies, the original and the copies of 3 particular kind of works that are computer programs, cinematographic works, and works embodied in phonograms. This one is a very musical works, basically. This one comes from the Article 7, in which that describes deeply how much even this right is just applied to particular authors, the one of computer programs, cinematographic works, and works embodied in phonograph. But such exclusive right, the right has to prohibit any commercial utilization, commercial rental of the original or the copies will not apply. 1. In case of computer programs where the program itself is not the essential object of the rental, while 2, in the case of cinematographic works, it won't be applied unless the commercial rental has led to a widespread copying of such work, and thence impairing the right of reproduction, the right that in 1886 was followed by the Berne Convention, right? So, in case you are a software developer and you are a computer programs developed by you, and you want to apply the rights of rental to it, you won't be able to do that if the rental had not the main focus into the program itself. While if you are a cinematographer, you won't be able to do the same if actually the rental had not generated a systematic and out of control copying that had impossibilitate you to actually apply a right of reproduction, because you don't know in any way possible who has the copies and who hasn't. So you don't know anything anymore. So widespread that it's all out of control. So instead of going to each of this person, you actually go against the person that has rented the thing to each of them. For how much is that possible? This one is Article 7 of the WIPO Convention. So for now we have 3 and 2. The Berne Convention 2, remember reproduction and right to reproduction, and the right to public performance, right to reproduction at Article 9, right of public performance at Article 11. Then instead of WIPO you have right of distribution at Article 6, right of public communication at 11, and at 9, at 9, and then the right to rental, always in the WIPO convention at Article 7. Article 8, sorry. Temperature all the time. Now, a last important part, that is from the Berne Convention of 1886, don't I make a mistake there, is the moral rights. Okay, the moral rights are seen in Article 6 bis of the Berne Convention and are considered as we say, the authorship right and the object to distortion, mutilation, or modification that could be derogatory or prejudicial to the honor or reputation of the author. These two, since the Article 6 bis, are super important because they're gonna be super used, for example, in Germany, okay? But in US they entered very late, like in the 90s. Actually, they entered, so after almost 1 century that US, that the Berne Convention was actually generated. So let's go to see the second extra. So this exclusive right in each jurisdiction, that is China, US, and the EU, the European Union. So I've tried to do something pretty funny because I know that this is a particular boring topic maybe, but a little bit boring. So actually all the next slides I'm gonna use a work of art. I hope you're gonna enjoy it. So how it is the copyright structure in US. This is defined by section 106 of the Copyright Act. In here is clearly written that the rights that are mentioned are basically this one, 6 rights that are right to reproduction, derivative work or adaptation right, public distribution rights, public performance right, public display rights, and digital audio transmission rights. Some of these is gonna apply basically to specific categories of work. This definition of exclusive economic rights that are connected to copyright are defined in section 106. So let's go to see. The first one is the right to reproduce, okay? The right to reproduction, okay, is the right, as we've seen before, to prohibit, authorize or not authorize the copies of the copyrighted work when it is violated in 2 ways, in literal or non-literal ways. Literal is straight or copy, okay, so it's the simple act of copying the work as it is, while non-literal means that some modification was done to the work, so it's not actual copying, it's modifying a little bit the work. So how they're gonna assess if this right was violated in the US? This is gonna, in the case of infringement, they're gonna use a substantial similarity test. This means that first of all, it's related to if there is the 2 prongs. One is, was there actual copying, yes or no? And then the substantial similarity prong, that is the one that actually gives the name of the test, that is, did this copying produce a substantially similar copy? The first question could use 2 main types of evidence. One is direct, so an admission of copying, or circumstantial, that means that is inferred, okay, by 2 main prongs. One is the accessibility of the copyrighted work by the infringer, and secondly, the striking similarity. An evidential similarity is called by the court. This could be done both with technical assistance and the breaking down of the work. But the second question, okay, so the striking similarity is a subjective determination for the jury. So the second part of this evidence, okay, will come without the technical assistance, nor with the breaking down of works, so with the dividing of works and checking what is copyrighted and what is not, okay? The jury have to decide about the topic without any external help, and basically taking the work as a whole and see if there is striking similarity, evidentiary similarity or not, while the accessibility is assessed by the judge. So if the infringer have the possibility to actually copy the thing because he could access it. So notable cases in this slide are basically three. You have Bright Tunes Music Corp versus Aring Songs Music Limited, in which it was mentioned that unconscious copy are still considered as infringement, but there is still the possibility for independent generation, and in that case is not considered as an infringement. Okay, so there is a fair equilibrium, a very fragile equilibrium between infringement and non-infringement, because independent generation is non-infringement, but unconscious copies, so it's all based on the accessibility, right? We've seen before, on the accessibility and the similarity. So if there is a great similarity, the jury finds great similarities, while the judge have found that there is ground, there had been the possibility for you to actually access the work, then you get unconscious copy, okay, and that's infringing. If instead there is non-accessibility, you will have non-infringement because of independent generation. If there is no striking similarities, that case is non-infringement because there is no copy, okay? So, second case, Cartoon Network versus CSC Holdings in 2008, in which the court held that temporary copies could not be deemed infringing because they based it on the principle of 17 U.S.C. section 101, if you remember, the one we've seen before, that defines the subject matter, that underlines that fixation shall exist for more than a transitional period. So if there has not been a fixation and there has been temporary copy, this is not infringing under Cartoon Network versus CSG Holdings in 2008. Then final case, Harney versus Sony and AE Television Network, in which it was stated how much the infringing must be based on copyrightable material and not on what is not copyrightable. In that case, Harney was a photographer, had made a picture and noticed that Sony and AE had made another picture that was striking similar, but similar just in the pose of the persons, okay? In that case, it wasn't considered as infringing because it's clear that he's missing one of the two prongs, okay? That is having a subject matter that is copied. In this case, it wasn't copied, something that was under the copyright law, because there were some facts, the fact that the person were posing in a particular way, that are facts that are something that is non-copyrightable. Now, we're gonna see even the question of software reproduction, okay? Because in software reproduction, the court have developed a new kind of test, similar to the substantial similarity test, that is the Altai test or the AFC test, so the abstract filtration comparison test. In this way, the first thing the court does is assessing if the software could be described in circles of abstraction, and so on multiple levels basically. Secondly, there is the filtration stage, in which the court aims to discern which ideas are stemming from, which ideas that comes from the cycles could be copyrightable and which one couldn't. Finally, There is the comparison phase that happens after this two, in which that is similar then to the similarity test that is done at the end, a second prong of the similarity test, in which what is copyrightable is then compared with in terms of similarity between the infringer and the original work. In this case, this one is a variation of the substance similarity test, as we said before. As it is a variation, the jury could use experts, could call someone external to actually understand the subject matter when identifying if there is a striking similarity and thence an evidentiary similarity. This one is considered as it is necessary even to understand the subject matter of softwares, basically. Then let's go further. Now, always section 106, subclause 2, instead talks about the right to the derivative work. So that is actually the exclusive right that aims to controlling the downstream market that comes from the original work. This means that copyright protection, in order to work for derivative works, needs to have something else, needs to have that spark of creativity that we talk about in faced versus rural, right? Versus rural link, right? That is what is needed. So if the derivative work could show such spark of creativity, so much that actually starts to pass the idea of a direct link, an authorship directive link, then there is a neighboring rights to copyright for the derivative work. If not, then reproduction right, or in this case the derivative right, had been applied. Derivative work is defined at section 101 and basically is translation, is all the neighboring rights basically. So translation, music arrangement, dramatization, fictionalization, motion picture version, and so on. Revision, annotation, elaboration, other modification, which as a word represent an original work of authorship, is a derivative work. You see, okay. Next, subclause 3 of section 106 is the right to distribution. This one is, as we seen before, talking about the WIPO at article 6. See, I remember. At article 6, the copy is a reproduction by patent expansion. Distribution is considered the transfer of ownership or any other type of agreement that shares the utilization rights, rental, lease, or lending. Section 109, letter A, describes the first sale doctrine. This one is very important, we're going to see why. Because provided that a person that obtains ownership of a lawfully made copy, a person may sell without the approval or the authorization of the copyright owner, you see. Notable cases will be in 1988, Quality King Distribution versus Lanza Research International, in which the first sale applies to US manufactured works, first sold abroad but later imported in the US in the US by a third party, while Kirtzang versus John Wiley and Sons of 2013 applies the first sales even to goods that are manufactured abroad, later imported into the US. So Quality King Distribution in 1998 applies the first sale doctrine to goods that are manufactured in the US, taken abroad, and then later reimported in the US, while Kirtzang in 2013 actually applies to the first sale even to goods that are manufactured abroad and later imported into the US. So let me just go to take a sip of water. So let's return to our beautiful presentation. Beg your pardon, but I noticed that after a while I talk, I need a little bit of water or anything. Okay. Okay, so we've just talked about the right of distribution. That is actually subclause 3. After subclause 1 and subclause 2, subclause 1 is the right to reproduction, and subclause 2 instead is the right to derivative work. This one all under section 106, and we mentioned how much subclause 2 reference section 101, which define derivative works, while section subclause 3 actually refers to section 109, letter A, that instead mentions and describes the first cell doctrine, or what in Europe is described as the Exhaustion principle. So subclause 4 and 6 mention the right to public performance. So in the case of any of literary, musical, dramatical, or choreographic works, motion pictures and audiovisual work, and in the case of sound recordings, to perform the copyrighted work publicly by digital audio transmission. This one is the right to public performance, as in subclause 4 and 6, which, as we have said, as inside of it two main definitions of the public. That is one, the physical public, while the second is the transmitting clause. So when it's transmitted using a device, that people will receive it in the same place or at the same time. Okay. So you will have a location clause and a transmitting clause. The second one was considered for broadcasting, and this time the notable case here is American Broadcasting Company versus Aero Inc. In 2013, in which Aero Inc. was mentioning the fact that they will not provide a broadcasting, but their technology would actually provide you with a personal channel, and with the possibility of having a personal antenna, a personal satellite that provides you with connection directly to the channel you like, in order to have direct streaming whenever you want. That's why the broadcasting company didn't like it, because they considered it as a copyright infringement under the idea of the public performance right. So the court actually found out that Aero Inc. services captured the public performance right, and until there were some differences in essence in the company was operating with the same result as a public cable company, and thence public performance right would apply. What is important for us is that this means that even if a right loosely applies to a particular technology, it's going to be applied in US. Then that's what is important for us. Last but not least is clause 5, that is of section 106, that is in the case of literal, musical, dramatic, choreographic words, pantomime, the work public, that is the right to public display. Such right is similar to the one of public performance, but the right of public performance, but the later applies just to peculiar categories as highlighted in subclause 5. A public display is any type of portrayal of a protected work that can be perceived. Fair sale doctor have been extended to the public display, right? Took limited at the place when the content is located. So the first sale limitation. This one is a first sale limitation. Now let's go to see the European law. So the European copyright is harmonized by the Copyright Directive in 2019 and the InfoSoc Directive, the Information Society Directive in 2001. However, the copyright matters are still not fully harmonized, and so we do whatever we can. The main 4 economic rights that are recognized in the European Union are actually the right to reproduction and Article 2 of Information Society and Article 3 of the right of communication to the public from Information Society, as well as Article 4 is the public distribution rights and the rental rights that instead are regulated by the Directive 2006/115. As before, some of these rights are attached to just specific categories of works, especially the right of communication to the public. These rights, anyway, are expanded or deepened by the case law by the European Court of Justice. So, let's start from the reproduction right that is mentioned in Article 2 of the Information Society Directive, and that mentions that member states shall provide the exclusive right to authorize or prohibit direct or indirect, temporary or permanent reproduction by any means and in any form, in whole or in part, to all these categories. Basically, pretty broad. Notable cases are the one of InfoPac, that is C5/08, that is from 2009, in which it is stated not only, as we've seen before, InfoPac mentions the expression of authors' own intellectual creation. But this case is even important as explain that even a part of the work can infringe copyright if that part expresses the author's intellectual creation. Then we would have art and all posters international BV versus the strict pictoright. This one is remembered as pictoright. so C419/13, which is mentioned that creating a new object that incorporates an image of a protected work constitutes a new reproduction. Okay? Constitute a new reproduction. Then we will have the Pelham case, so C476/17, which is a reproduction of a sound sample from a phonogram, is generally considered a reproduction of that phonogram, but not if it is modified to the point of being unrecognizable. Okay, in that case, it's not considered as a reproduction. Now let's see the exclusive right of communication to the public and the right of making available to the public the subject matter. As we say, this one is very important in relation to hyperlinks and download and so on. This one is for Article 3. Okay, that gives a specific indication of who can use such right. Besides that, in the European Union, there is a clear separation between public performance and communication to the public. This one is not instead present in the US. What are the notable cases here? From one side, you will have Svensson versus Retrieversverket AB, which is C466/12, in which the ACJ established that a secondary transmission to the public does not violate the right to communication unless the transmission reaches a new public that is not contemplated in the original transmission, or is achieved by a different technical means from the initial mode of transmission. What does it mean? That if with the new transmission I achieve and then I connect with much more people than the original transmission was intended for, then I would have I would actually violate the right to communication. Or if that transmission is achieved by different technical means that the initial transmission was intended. Then, Finspeller case, that is in C527 C527/15. In that case, it stated that knowledge is a crucial factor, and as well as the intention to make profit for concluding if the sale constitutes communication to the public. Then we'll have Steam and Semi, that is C753/18, which in the case establishes that the user makes an act of communication when they intervene, fully aware of the consequences, to provide their customers with access to a protected work. Finally, this one is a strange name for the case, because it's BY versus CX. I think they just redacted the names, but that's the way in which they're reported. That is C637/19, in which the case emphasizes that communication to the public must contain a clearly defined and closed group of persons and not an indeterminate number of potential recipients. Hence, you will need to have a specified number of people which are going to receive the communication and not just a closed number. Then we're going to see Article 4 of Information Society Directive. That is actually the exclusive right of distribution, which gives which, as we say, gives the exclusive right to the copyright holder to actually not distribute or to distribute something. So to accept or not accept the right copy, and there is the distribution of this work. And even in the EU, there is the mention in Article 4, Section 2, Paragraph 2, of the exhaustion doctrine. Okay, in which the community is mentioned, in which within the European community is mentioned that the right of distribution is gonna be exhausted after the sale or the transfer of ownership. Notable case on these remarks are the Usedsoft case, C128/11, in which was mentioned that the resale of a Usedsoft license can exhaust the distribution rights, provided the original acquirer makes the copy unusable. Okay. Then there is the Tom Cabinets case. So if there is a license, even a Usedsoft license can exhaust the distribution rights if the original acquirer makes such a copy unusable. Okay. Tom Cabinets instead, that is C263/18. In this case, instead, is stated how the distribution of ebooks is not covered by the concept of distribution, but by communication to the public. The exhaustion applies only to work incorporated in a material medium. This one is the same principle, the one of Tom Cabinets, that actually applies to downloads and even to hyperlinks. So let's go further. These are the difference in the US and the European Union in relation to the exhaustion or first sale doctrine. In the EU, the exhaustion is always based on a material media. So there is an exclusion of digital media, as we said in the case of Tom Cabinets, and there is a focus on retention. Tom Cabinets was right. Yeah, Tom Cabinets in the Tom Cabinets case, and there is a focus and on the retention of the copy, as we said in the case, for example, of download. I've talked about this before. In the US instead, there is the principle that exhaustion should be applied even to digital media. The case here will be London SIRE Records Inc. versus DOE versus DO in 2008, which focus instead the full exhaustion principle on the download, upload discrepancy to the new copy that is made. In the European Union, although the concept of exhaustion is preserved, in case of leasing or rental of the copy, remuneration is still foreseen. This one by Article 4 of the Directive 92/100 HESI from 1992. In the European Union is granted the right, and then as per KC 355/96, which is related to trademark, but it will be applied theoretically even to copyrights to prevent the entry in the European Union of a copy from outside the European Union, even if it is a lawful copy. Instead, in the US exception, with the exception of phonograms and computer programs, the right to control the disposition of the tangible copy by rental is transferred with the ownership of the physical copy, as per Article 17 USC sections 109A and B. Okay? Instead, in the European Union, we have seen that remuneration is foreseen in case of leasing or rental of the copy, although the concept of the exhaustion is preserved. Okay. Then, in the US, under Kirtzang versus O'Malley and Sons that we've seen before, there is a statutory rights to prevent importation of copy. Statutory rights to prevent importation of copies does not apply to copy that are lawfully made abroad. Finally, the European Court of Justice established that the duration and terms of a lease would determine if it is a sale or it is not a sale. It's not just enough to have the name. This one is C12811 in 2012. This means that it's more risky basically to the leasing in a broader term because it would be considered a sale, and then you would use the exhaustion principle. Instead, with a lease, as we say, the remuneration is still foreseen. The Article 4 of the Directive 92/100 EC from 1992. So let's proceed. Finally, rental rights of the Article 3 of the Directive 2006/115, in which the right of rental is the right, the exclusive right of giving a specific indication of who can use such right, and the right to authorize or not authorize the rental of a copy. The directive underlines how rental means making available for use for a limited amount of time for economic or commercial advantages, while lending means making available to use for a limited period not for economic or commercial advantage through accessible establishment. Okay? Essential directive is even foreseeing the possibility of exception by member state, for example, due to fair use. Now, let's go to say instead the last bit of our comparison, that is the Chinese law. Okay, the copyright structure in China is way more broader than Section 106 in the US, or Infosage Directive and Terms Directive and so on in the European Union. Okay, basically there are 17, I'm not joking, rights that are defined by the ARL, and these 17 rights does not have the differentiation between moral rights and not. What we know by the letter of the articles, or the Article 10 of the IRL, is the fact that from subsection 5 to subsection 17, these rights could actually be transferred. Okay, their ownership could be transferred. But subsection 17 basically is an open close section that leave the possibility of funding any type of rights by the law itself. So it's pretty interesting that. So there is a debate of which one of these rights is economic, which one is hybrid, which one instead is different of any other type, which one instead is a moral right. But what is important for us is that basically they have a right of publication, right of authorship, right of alteration, right of integrity. These first four rights are not transferable. This makes us think that they are hybrid or moral rights, while we know that right of reproduction, distribution, rental, exhibition, performance, projection, broadcasting, communication through information networks, cinematography, adaptation, translation, and compilation are instead transferable, and then this makes them connected to economic rights, basically. Now let's start to have a brief overview. So subsection 1 is the right of publication, that is the right to decide whether to make a work available to the public. So this one is the right of publication, that we will call the right of communication to the public. Article 30 IRL established that the publisher may be subject to the consent of the author, and under Article 31, publisher must pay remuneration to authors and to authors of derivative work. This one under Article 34. In the absence of declaration of the contrary by the copyright owner, a journal or newspaper may virtually take the fruit of another journal by reprinting an article. Article 32, paragraph 2. They can modify without the consent of brevet, but it's necessary if the intent is changing the authorization. This one under Article 33, subsection 2. So we have then a series of rights. This one is Article 10, subsection 9, 10, 11, 12, 13, which are normally treated as rights and obligation of performance, producer, and broadcaster in their derivative work and connected to their neighboring rights. Okay? A performer is entitled to reproduce the work of another without authorization, subject to the requirement of remunerating the copyright holder under Article 35, paragraph 2. When performing derivative work, the performer must remunerate the copyright owner of the derivative work and the owner of the original work. Under Article 37 of the ARL, the video producer shall always require authorization both of published and unpublished work and pay remuneration. Under Article 42, a broadcaster is entitled to use a published sound recording for non-profit broadcast without authorization from the copyright holder. All these rights are based on the Rome Convention of 1961. Article 10, subsection 5 is the important right that we've seen before, is basically the right of reproduction, that in China is defined as the right to reproduce one or more copies of a work by printing, photocopying, rubbing, sound recording, video recording, ripping, duplicating a photographic work, digitizing, or by other means. This means any type of reproduction, the right of reproduction, as we've seen, and could be transferred. This one is the first right that could be transferred in its ownership. Notable cases, in this case is a case from 2020, that is Shanghai Li et al., that is related to the Lepin brand. That is very interesting because it was a copy of Lego, basically, and it's underpinned the necessity of substantial similarity of the copy in the artistic work. In order to do so, there's gonna be by the court an overlooking of the design, aesthetic, and specific element that make up the protected work. Is even interesting that in China the court assessed if the overall essence or the feel of the original work was replicated. So if something even more than a simple resemblance basically was done. This one is pretty interesting. Then we go with the right to distribution. Okay. That in China is regulated by Article 10, Section 6 of the ARL, in which is mentioned that the right to distribution is the right to provide original copy or reproduce a copy of a work to the public by sale or donation. The right of distribution under current Chinese copyright law is limited to the transfer of ownership of tangible copies of works. This implies that the right is specifically concerned with the physical dissemination of works rather than digital or intangible formats. In 2001, expanded the definition of works to include other intellectual achievements consistent with the characteristic of the work, and even apply given to the digital world. The current copyright law in China does not define the principle of exhaustion of distribution rights in its legal provision. In academic circles, however, the prevailing view is that the right of distribution and the principle of its exhaustion apply primarily to works on tangible carriers like physical objects. Notable cases could be considered a Beijing Motier Company versus Jumbo Library App, in which the court stated that the current copyright legislation in China presents challenges in applying the principle of exhaustion to the field of network communication. The court opined that even if this principle were to be introduced, it should at least meet the criteria of transfer of ownership of the original or copy, and ensure that after a work is digitized and transmitted, the stored file should be deleted to avoid uncontrolled replication, which could harm the interest of the rights holder. Due to the lack of evidence and inability to apply the principle of exhaustion of distribution rights to the constant, the court ruled against Jumbo Library. Okay, so it's interesting how the EU and China are actually on the same page here in saying exhaustion works just if there is a tangible media to work with, and tangible means that needs to be physical, right? And they would prefer in Europe, as we said, to use communication with the public, right, instead of distribution right, as something to be held in court, basically. Article 10, subsection 7, talks about instead the right of rental, that is the right of non-gratuitously permit others to temporarily use an audiovisual work or the original or copies of a computer software, except where the software itself is not the main object of the lease. Interesting, this one, because it's a direct application of the right of rental in the WIPO treaty, if you remember, under Article 7, and they reflected in China in Article 10, subsection 7, very interesting, that there is this particular limit to the right of rental. for example, a computer is leased with a software pre-installed and the main object of the lease is the computer itself rather than the software. In this scenario, this case will not fall under the right of rental. So finally we finish our brief overview basically of the whole thing, of the um, different exclusive rights that are granted in different legislation, even with some general talks. And now we're going to see the moral right, basically, of authorship and how he fights sometimes with the ownership and the transfer of it. As we said before, there is a moral right seen by the Berne Convention of 1886, Article 6 bis, that is the right to authorship, right? And the main issue here is basically, is how this moral right, if implemented, works with the concept of authorship, with the concept of ownership, and that's when the ownership is transmitted, for example, in the employer relation and so on. And especially how does it work with new technology. There is a monist and there is then a dualist approach. In a monist system like in Germany, the economic and the moral rights are linked together, and hence the transfer of ownership could just happen with the death of the author, of the the death of the author, okay? And licensing becomes a more viable solution. Instead, for dualist system like the US, the two types of rights could be split and ownership could be sold while authorship could not, also recognize it as a moral rights. But let's see in depth. As we say, in the US is one of the latest to actually implement the moral rights, and then implementing 1990, introducing two of them, integrity and attribution, but limiting them only for the lifetime of the author and only for works of visual arts that exist in just one copy or in limited editions, and less than 200 copies that will need to be signed and numbered. What we see here is that moral rights basically apply to such a small part of the whole of it. Moral rights does not apply, for example, to software, but just to works of visual art that are scarce in number, basically. But let's see them. So we will have two means of them under section 106. A, that is authorship, that is called attribution, in which the author of work of visual art shall have the right to claim authorship for the work and to prevent the use of his name as the author of any work of visual art which he did not create. So we have in 106 1a the positive part, and in B instead the negative part. In 106b instead we talk about the integrity, that is the shall have the right to prevent the use of his or her name as the author of the work of visual art in the event of distortion, mutilation, or other modification of the work which could be prejudicial to his or her honor or reputation. This one is seen in light of the right of the Article 6 bis of the Berne Convention, as we talked before. So, work made for art, that is the first case we talk about, right? And the main issue we talk about, in which there is conflicting parts, basically, no? The works made for eye means that the employer or the person from the work was prepared is considered as the author for purposes of this title, and unless the party that expressly agrees otherwise, owns all the comprising the right. So US copyright law goes so far as denominating the employer the creator of a work made for hire. So, and the work made for hire model in the US puts the authorship in the hands of the employer, basically. Okay. Let's see the EU. This one is pretty fast because human rights are not codified in a on a European level and instead are left to the national legislation, in which, for example, UK and Germany have a lot of differences, but even Italy, Spain, and so on. Generally, when we talk about work for hire, then the creator, the employee, retains the moral rights, while the economic rights stay in the hands of the employer. But this does not apply, for example, in some countries, like for example Germany, that as we say is a monist approach. So even in that, there is no harmonization, so it's pretty broad. Okay. Let's say instead China. Article 10 actually takes the moral rights, so you have the right of authorship, the right of alteration, and the right of integrity. Defined immediately in the same article that defines even the other rights. And Article 9 then foreseeing authors and non-authors, and foreseeing authors as one whose name is affixed to a work shall be regarded as an author if no evidence of the contrary. There could be a license from the rights under Article 10, and there will need to be even remuneration for it. Now let's go with the concept of work for hire in China. Actually, the concept in China under Article 16 of the RR is way more tighter than the one in the US. Why? Because job-related works are the one in which the idea of the relationship between employer and employee is applied. Okay, the employer has some rights, has not the ownership though, because he has a veto on licensing and priority right on the sale. But the ownership as well as the authorship is on the creator. However, there are three main exceptions. The one is that employer sponsors, supports, or give some directions. And if such employer bears the responsibility of the creation, and finally, if the work expresses the employer's will and intent, this one is the idea of chuche, that means being on top, so managing the thing. So if the employer basically manage the whole of the thing, then in that case the employer could be considered as the owner and the author of the copyrighted work. And now the part that I love most, honestly, that is the one related to contemporary technology, so copyright authorship and tech. So let's talk about database first, and the database authorship. So regarding normally the copyright protection in European Union covers works in the literary, scientific, and artistic domain, and would require the data to be original subject matter, specifically the author's own intellectual creation. Regarding database, the EU provides a sui generis rights that protects the substantial investment, the financial, material, or human investment made in obtaining, verifying, or presenting the database content. This protection is specifically important for databases that may not qualify for copyright protection but still represent specific investment. Okay, the sui generis rights applies to the database as a whole or a substantial part of it, and is granted automatically for 15 years from the creation date or public availability of the database. However, if a database contains some particular ingenuity, we could say, it could be considered as copyright. In the US, instead, databases are generally protected as compilation under copyright law. A compilation is defined as a collection and assembly of pre-existing material or of data that's selected in such a way that the resulting work as a whole constitutes an original work of authorship. The originality of creating the selection, coordination, and arrangement of data within the database are what is protected, not individual data's element. Okay? There must be a minimum level of creativity, as we have seen for first publication versus Rural Telephone Service Company, that ruled even that a mere alphabetical arrangement of data does not meet the threshold for copyright protection. And now maybe the best part, that is AI and copyright. So in US, I know it's pretty scary, this one, but in US there has been a case that is Thaler versus Perlmutter that confirmed that any artwork that is generated by an AI is not entitled to copyright protection, as does not recognize the agency of the machine. While in Europe, in the case of painters that deals with photograph, as we mentioned before, underlines the intellectual creation must be from a human agent, and AI clearly lacks personality under EU laws. We've seen before even in the opinion of the Advocate General Trignac that reminds that human agency is clearly seen even in Article 6 of the Term Directive and in all the copyright legislation basically of the European Union. So let's return to our copyright in general discourse, we could say, and we're gonna see the copyright limits. Okay, this one is, we almost finished finally. It's already more than 1 hour that I'm talking to you guys, but we have to finish, so it's not too much, bear with me. So there are 4 main limitations as seen in the Berne and all other international agreements, that is duration, the chain boundaries, the permitted use or fair use, and the non-material works. So the Berne sets a minimum standard of 50 years post-mortem notorious protection of the right, and foreseen at Article 9 Article 13 of TRIPS and Article 10 of the WIPO Copyright Treaty, the possibility of exceptions for the permitted use. Now let's see the US. In the US, the regulation is under Section 302, under Section 302, which is defined as 70 years, and in Section 302 is mentioning that whenever the author is unknown or is a pseudonymous work, the copyright in use for a term of 95 years from the year of its first publication, or a term of 120 years from year of its creation, whichever expires first. Okay. Then the fair use doctrine is very important, because in US the fair use doctrine doesn't generate from the copyright source, but is a dialogue that started in court and stayed in court basically. And indeed the first time it appears is in Fossum versus Mars in the 19th century. Okay, and it wasn't codified until 1976. The Congress wanted in 1976 though that the fair use remained a case law based doctrine, and therefore drafted Section 107 listing 4 main factors. Okay, purpose and character of the use, that is the most important, the nature of copyrighted work, the least important, the amount and substantiality of the copying, that is a contingent factor that is tied to the purpose, and the effect of that copy in the market value of the original for extending evidence or as an evidence factor. This one is to apply context by context on case by case by the judges, basically, when determining if it is a fair use or it is not. There is even in 1994 there has been, in the case Campbell versus Acuff Rose Music, an evolution of it, that is the transformative use, that is considered when the work modifies, the work is modified, or it is transformed in a way that is giving it a new purpose, a new content, or a new meaning. And this is what makes it transformative. This is not automatically fair use, but it's still going to be the first factor, for example, in what is parody. Now let's see the European law. The European law is normally 70 years, but it could change because even this is not harmonized, it's decided by the member state. Regarding to anonymous or pseudonymous works, under Directive 2006/116/SC, that is the one even that was about the rental, it would endure for 70 years from the date on which the work was first lawfully made available to the public. Let's talk about the lawful use. This one is very important, very interesting, defined in Article 5 of the Information Society Directive, and clearly states four main exceptions, that are the temporary reproduction, the private use, the use by libraries and educational establishment, and finally the quotation for purpose of criticism or review. These exceptions are offered in specific cases and do not conflict with the normal and shall not conflict with the normal exploitation of the right, as well as do not unreasonably prejudice the legitimate interest of the right holder. It's clear that this one is taken from Article 9, paragraph 2 of the Berne Convention. Right? If you remember that we talk about this. Finally, last slide, guys. Last slide is about infringement and remedies. So we talk about what could be the possible infringement. We're talking about every kind of right, and what could be the possible solution. So in court, the possible solution would consist normally of civil redress, reparatory action, or ceasing and desist, or injunction for ceasing and desist. In the UK, there is even the Anton Pillar order that comes from the Anton Pillar KG versus Manufacturing Processes Ltd. in 1976. It is a case in which the court granted an order for permitting the inspection of premises in which it was believed that some particular activity was carried out that was infringing the copyright of the plaintiff. This one, my friend, is finally the end. I hope I described everything pretty good. My aim, as I said, is to actually do one of these things every night, not tomorrow because it's the end of the year, but still I aim to do so, and eventually then to actually have the next one is patent law, then trademarks, and then basically finish up there with IP law and doing with the other exam that we have. Have a good night and see you soon.